So I'm going to bring up one more subject and then we'll go to the floor. And the last chapter of the book deals with the post-9/11 War on Terror cases and situates them against the backdrop of the Supreme Court's handling of the Korematsu case, the Japanese internment case during World War II. And I was interested in this is an area of interest of mine, and I was particularly interested in this discussion because it's an area in which it has been argued, including by me, that the court's activity actually produced significant unintended consequences. That is, people, in an effort to bring law and judicial oversight to Guantanamo, the court created a kind of an incentive never to bring anybody new to Guantanamo and to keep people in less visible facilities farther away and actually in detention by proxy forces that aren't even part of our custody at all. And so I'm interested in the question of where consequences are foreseeable in that regard and where they're not. And how should we think about a decision that creates a real rule of law environment in location A and thus incentivizes the use of location B, which would not be covered. Now, no one will ever go to Guantanamo again for precisely the reason that the people who are there now were brought there. How should we think about that?
I think that's such a good question for the reason that those examples give me the opportunity, or what I try to do, what I want to do is I want to give people a little feeling for the uncertainties that are there in my job. It could be me or it could be anybody else who's holding this job. And you're often facing a kind of void where there are good arguments on both sides and a lot turns on it. And you cannot be certain that you're taking the right view. And that isn't false modesty. And these examples allow me to show that. The Korematsu, I can remember driving with my mother just after the war in San Francisco past Tan Fran racetrack. As I grew up in San Francisco, and Tan Fran, she said, I can remember her saying to me, that's the place they held the Japanese in World War II a few years ago. And the voice of approval was not hers. I mean, she was pretty disapproving of that. Because what had happened is in January 42, the president signed an order, and General DeWitt, the head of the Sixth Army in the Presidio in San Francisco, ordered the Japanese, that means any American of Japanese origin, as well as those who were not American citizens, to report to Tan Fran and to Santa Anita near Los Angeles and other location places. And 70,000 American citizens of Japanese origin were removed against their will and put in camps in Eastern California and the Intermountain States. Now, by 1944, that case got to the Supreme Court, brought four Japanese Americans brought cases. And the one that's best known is Korematsu. I met him, actually, Fred Korematsu, because my next-door neighbor in Cambridge, just by coincidence, is the daughter of a man named Ernie Bezig. And Ernie Bezig was a friend of my father's. They used to play poker. And he was head of the ACLU in San Francisco, and he defended Fred Korematsu, and the ACLU wouldn't sign the brief. Now, there are a lot of politics behind that. But part of the fact that there was politics behind it shows the difficulty that was going on at that time. Pearl Harbor had been bombed only a few months before. Now, Fred Korematsu, who I really liked, actually, he's a kind of feisty fellow, and he was I could see why he brought the case against his parents' advice, against the advice of the Japanese community there. And he brought it. And Bezig represented him on his own. He said, we're going to get you out. They can't do this. They can't do it. And by the time the case got to the Supreme Court in 44, the main arguments, DeWitt had written a long report, and he had said, the Pearl Harbor, and we were afraid of an invasion, and it is true. I can remember blackout curtains being drawn. We're afraid of an invasion. And there's signaling going on from the shore to submarines, and there are 5 incidents of sabotage that were helped by Americans of Japanese origin, and there's just no time. We have to remove them all. It's too dangerous. It's too risky, and he did it. All right. By 1944, when this case comes to the court, a couple of lawyers in the Justice Department had grown a little suspicious of this argument, which they'd read many times, because the head of Naval Intelligence had written an article in one of a public magazine saying we had this under control, there was no need to do it. We knew who the people were who were disloyal, and they weren't these people we moved. So he calls in the Federal Communications Commission, and he says, with signaling, he says, was it going on or not? And he asked the FBI to look into the espionage, and within 2 weeks, the FCC's back in office. His office is Berlin, and I forget that's whatever. And they're back in the office, and they have books like this. And the FCC man says, no, there was no instance of signaling. There were 700 and some odd reported instances. We've looked into every one. Most of them were just buck privates misinterpreting something on their machines, just been drafted. There was not one. We looked into every one. And he said, well, how did you do this so quickly in 2 weeks? He said, oh, no, we didn't do it in the last 2 weeks. We did it at the time. And we showed it to DeWitt at the time. And the FBI said the same. With the 5 incidents, 3 of them took place later, and they said that J. Edgar Hoover was totally against it, which he was. And he said, we told DeWitt this at the time. So the 2 lawyers said, well, we can't send a brief up to the Supreme Court where we're underwriting this opinion, which is false. And they wouldn't sign it. And then they brought in to mediate Herbert J. Wexler, who's a person that some of us know. And he got them to agree to a footnote, which was so obscure you couldn't understand it unless you read it 5 times, and then you saw what it meant. All right, so fine, they signed it, went to the court, and Charlie Horsey was the ACLU lawyer in the court, and he read the footnote. And he made absolutely certain that every judge on that court understood what it meant. Now, Korematsu loses. 3 votes against in the dissent. Jackson, Roberts, and Murphy. Right. Now, of those 3, Murphy, I thought was the best one. And he really said there's no evidence, there's nothing, up, down, and sideways, there's not one reason to do this. He's in dissent. The people who uphold this are not sort of history views them as some kind of reactionary judges. Black wrote the opinion. Hugo Black, the greatest civil libertarian on the court. Douglas, Frankfurter. So the question that comes to me, which is, I think, why? And I think as you read that, this is my construction I put upon what they've written. Why? Because they're thinking someone has to run the war. Either Roosevelt runs it, or we run it. And we can't. And even if we decide this case, what about the next case? We just can't do it. So we have to give him this authority because we're fighting a war. And Jackson said, well, we were fighting a war. We're not. It's 44. What you ought to do, and he has his own theories, which you can go into later if you want. But in any case, why did they do that? I think that's why. They're afraid to get into this. Now, in my own mind, that poses the problem. And the fact that Korematsu is viewed as a really wrong decision suggests that it is at least a problem of how this Constitution, which has civil liberties listed, how do you hold a president who has the war power and who is responsible for national security? How do you hold that president accountable in times of national security danger or war? And I think, in my mind, the 4 Guantanamo cases are an effort to answer that question. And they are all decided in favor, really, of the Guantanamo person or the person who was held. For example, bin Laden's driver. Not the most popular person in the United States. And the court held in favor of that driver as opposed who was suing the most powerful person, the President of the United States, who lost. And how? I wanted to put enough in here so people see that partly the answer has been holding them accountable by being very narrow in what you hold, in being very specific, in leaving lots of outs, going to statutory questions first. But ultimately, we decided umedian, and we said that Congress could not suspend the writ of habeas corpus applicable to the people in Guantanamo. And Guantanamo, the court says, is really part of the United States. And we went through the treaties and all the different things to show that it was really the United States had full leeway there. But what we're doing in general in those cases, I would say, is trying to be narrow, thereby satisfying, of course, no one. Because there are some groups that think we should have been definite and broad, and others who think we shouldn't have gotten into it at all. And so I put that there without too much commentary, so that people who read it can compare it to Korematsu and ask, is this approach likely to work to the problem of civil liberties and the need for national security that Korematsu poses? And I think, I suspect that people, by the time that they're through reading it, will think, we can't be sure. Oh, you said something like that, you can't be sure. Well, you can't. You can't. And the most you can do, and I think this is why they're quite limited in their holdings, is to make an effort that you then hope as best that it will work out better than the alternatives. And that is very much the job of the court with very difficult matters, such as weighing the genuine need for national security, the genuine concern for civil liberties in time of a real crisis of national security or wartime. And again, you go back to the beginning. This gets us right back. Why in heaven's name should 9 people who are not elected decide things like that? The only answer being the alternatives seem worse. That was Hamilton's answer. And to let the public try to understand both the difficulties of that and the importance of it. I mean, I see the importance every day in the court, where I see people of every race, every religion, every point of view, and they're in that courtroom fighting out their differences under law. You see, we're back to the beginning, because I think that's so much preferable than using violence in the streets. All right, there we are. No good answer, but trying to explain what it's like.